Good afternoon, everyone. I am Eric Barcinia, BScreen 4A at State University of Northern Negros. Today's topic is about Rule 117 of the Revised Rules of Criminal Procedure. Without further ado, let's get to it. Rule 117, Motion to Quash. Section 1. Time to move to quash. At any time before entering his plea, the accused may move to quash the complainant or the information. This means the motion must be filed before the accused officially responds to the charges in court. It's a critical deadline for the defense. Section 2. Form and contents. The motion to quash shall be held in writing, signed by the accused or his counsel, and shall distinctly specify its factual and legal grounds. The court shall consider no ground other than those stated in the motion, except lack of jurisdiction over the offense charge. The motion needs to be formal, written, signed, and clearly state why it should be granted, both factually and legally. The court generally sticks to only to the reasons you provide, unless it's about a court lacking authority over the crime itself. Section 3. Grounds. The accused may move to quash the complaint or information on any of the following grounds. A. That the facts charged do not constitute an offense, meaning the complaint's allegations simply don't describe a crime. B. That the court trying the case has no jurisdiction over the offense charge. This means that the court hearing the case doesn't have the legal authority to handle this particular type of crime. C. That the court trying the case has no jurisdiction over the person of the accused, and D. That the officer who filed the information had no authority to do so. The prosecutor or the officer who initiated the charges didn't have the legal power to do so. E. That it does not conform substantially to the prescribed form. This means that the complaint doesn't follow the required format or content set by law. F. That more than one offense is charged except when a single punishment for various offenses is prescribed by law. This means only one offense should generally be charged per complaint unless the law specifically allows multiple related offenses to be grouped. G. That the criminal action or liability has been extinguished. H. That it contains averments which, if true, would constitute a legal excuse or justification. And lastly, I. That the accused has been previously convicted or acquitted of the offense charged, or the case against him was dismissed or otherwise terminated without his express consent. This means that the accused has already faced judgment for the same crime known as double jeopardy. Section 4. Amendment of the complaint or information. If the motion to quash is based on alleged defect of the complaint or information which can be cured by amendment, the court shall order that amendment be made. If it is based on the ground that the facts charged do not constitute an offense, the prosecution shall be given by the court an opportunity to correct the defect by amendment. The motion shall be granted if the prosecution fails to make the amendment, or the complaint or information still suffers the same defect despite the amendment. If the problem with the complaint can be fixed, the court will generally allow the prosecution to amend it. But if the problem is fundamental, like the facts simply do not forming a crime, and the prosecution can fix it, then the motion to quash will be granted. Section 5. Effect of sustaining the motion to quash. The motion to quash is sustained. The court may order that another complaint or information be filed, except as provided in Section 6 of this rule. If the order is made, but the accused, if in custody, shall not be discharged unless admitted to bail. If no order is made, or if having been made no new information is filed within the time specified in the order, or within such further time as the court may allow for good cause, the accused, if in custody, shall be discharged unless he is also in custody for another charge. Section 6. Order sustaining the motion to quash, not a bar to another prosecution. The exception is an order sustaining the motion to quash is not a bar to another prosecution for the same offense unless the motion was based on the grounds specified in Section 3G and I of this rule. This generally means getting a case quashed doesn't stop a new case for the same offense. However, if the case was quashed before the criminal liability was already extinguished or because of double jeopardy, then no new case can be filed. Section 7. Former conviction or acquittal. This is double jeopardy. When the accused has been convicted or acquitted, or the case against him dismissed or otherwise terminated without his express consent by a court of competent jurisdiction upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had pleaded to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charged, or for any attempt to commit the same or frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charged in the former complaint or information. This is the essence of double jeopardy. Once you've been properly tried and either convicted or acquitted, or the case dismissed without your agreement, you cannot be prosecuted again for the same offense. However, the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charged in the former complaint or information under any of the following instances. A. The graver offense developed due to supervening facts arising from the same act or another omission constituting the former charge. B. The facts constituting the graver charge became known or were discovered only after a plea was entered in the former complaint or information. Or C. The plea of guilty to the lesser offense was made without the consent of the prosecutor and of the offended party except as provided in Section 1F of Rule 116. In any of the foregoing cases, where the accused satisfies or serves in whole or in part of the judgment, he shall be credited with the same in the event of conviction for the graver offense. There are exceptions to double jeopardy, primarily when a more serious crime arises from new facts or discoveries, or if a plea bargain for a lesser offense was made without proper consent. In these instances, a new prosecution for the graver offense might be allowed, with credit for time served. Section 8. Provision dismissal. A case shall not be provisionally dismissed except with the express consent of the accused and with notice to the offended party. Provisional dismissal of offense is punishable by imprisonment not exceeding 6 years or a fine of any amount or both, shall become permanent 1 year after issuance of the order without the case having been revived. With respect to offenses punishable by imprisonment of more than 6 years, their personal provisional dismissal shall become permanent 2 years after issuance of the order without the case having been revived. A provisional dismissal temporarily closes a case, but it can be reopened. This requires the accused's consent. Crucially, if the case isn't revived within specific time frames, 1 year for lighter offenses, 2 years for more serious ones, the dismissal becomes permanent, meaning it cannot be brought back. Section 9. Failure to move to quash or allege any ground therefore. The failure of the accused to assert any ground of a motion to quash before he pleads to the complainant or information, either because he did not file a motion to quash or failed to allege the same in said motion, shall be deemed a waiver of any objections based on the grounds provided for in paragraphs A, B, G, and I of Section 3 of this rule. This section emphasizes the importance of timing. If an accused fails to file a motion to quash or misses certain crucial grounds before entering their plea, they lose the right to raise those objections later. It's considered a waiver. And that's all for Rule 117. I hope that was understandable. Thank you for listening. Goodbye.